Okay, so good morning and welcome to everyone that is joining us today. Today we're holding yet another webinar to do with HIV, AIDS and TB discrimination. And we're very happy to be joined by two well-known speakers who've got a wealth of experience in the region, and that's Professor Anton Kok from the University of Pretoria and Jackson Mzila, an attorney from the South African Human Rights Commission who is based in Gauteng. So what we've been doing with the webinars to date is we've been looking at how the legislation protects persons living with HIV/AIDS, but we haven't dealt too much in the practicalities. And that's what we're hoping to do today with Prof. Anton and with Jackson, is how can legal practitioners use the law, but also use the mechanisms available, such as the Equality Court and the South African Human Rights Commission. So before we go into our webinar, I'm going to hand over to Teresa Yates, who will just be giving an introduction of probono.org's project in respect of HIV/AIDS. Teresa.
Thank you, Chantel, and thanks to everyone who has logged into this webinar. I just want to give a brief introduction to probono.org. We were established in 2006 to set up a clearinghouse of attorneys and advocates to provide pro bono services to people who otherwise would not be able to afford to pay for legal services. This particular webinar is part of a national program that we have, which is funded by the AIDS Foundation of South Africa through a generous grant from the Global Fund. Excuse me. The project is aimed at reducing and, if possible, eliminating discrimination and stigma related to key and vulnerable populations' experience of discrimination related to their HIV and TB status. We've had a number of webinars to raise awareness around the challenges we still face in South Africa with regards to stigma and discrimination against people living with HIV and TB. And this webinar is one of the series that we are hosting related to that. So I just want to welcome our panel of presenters, Martha Langa and Anton Kok, and they'll be walking you through the use of equality courts against unfair discrimination. I think it will be a very good and informative webinar, so we'll get on to it, and Chantel will properly introduce the speakers now. Thank you.
Thanks, Teresa. And so we're going to start off with Prof. Anton Kok. I think Prof. Kok is one of a handful of experts in the country about the Equality Court. He's done extensive research on using the Equality Court, and we're very privileged to have him today. He's a professor at the University of Pretoria. So, Professor, I'll hand over to you.
Thank you. Let me just check, is my screen still sharing or not? Let me just get it going again. Can you all see can you see the slide?
Yes, we can see it.
All right, right. All right. Thank you for the opportunity to present at this seminar. On that first slide, just please note my email address. I'm quite happy to take any follow-up email inquiries as well after the session. We'll have a Q&A as well, but if there are any other follow-up questions after that, please email me. I'm quite happy to liaise with you on any other questions that you may have as well. I think I only have about 20 minutes or so, so it's impossible to go through the entire Equality Act or what the Equality Act offers in its full scope. So this is a very broad overview of one more avenue that attorneys can utilize to assist in the battle against unfair discrimination on the basis of HIV and TB. So the entire presentation is premised on what the Equality Act offers, or why this is an avenue that can also be explored by attorneys. our Equality Act, the Promotion of Equality and Prevention of Unfair Discrimination Act 4 of 2000. Some refer to it as PEPUDA. I prefer the Equality Act, but it's the South African version of anti-discrimination legislation, or what the Americans call civil rights legislation. In the
contend that no, title to prosecute means literally.
Can I continue?
Yes, sorry, Jackson, can you mute your...
Employed at the MPA,
No, Chantal,
it's not you. Sorry, could everyone just mute their Oh, there we go. Okay, sorry, Prof.
No worries. All good. All right. Okay, so back to that first slide. What would the aim be of anti-discrimination laws? At its most basic, some governments simply put an act in place to say, well, we've done our bit. This is our commitment. We're showing our commitment to combating discrimination, but not much outside of that. Not really giving any resources to the enforcement mechanism. Not really publicizing it. Just putting the act on paper to tell the outside world, look, we've done our bit. The second bullet, and that's what most governments do, that is at least set up some kind of enforcement mechanism. Again, not necessarily well resourced, not necessarily well publicized.
Sorry, everyone please just mute their microphones. I see the sounds coming from, thank you.
All right. So the South African enforcement mechanism for the Equality Act are our equality courts. Almost all magistrates' courts have an equality court, all supposed to be equipped with trained clerks and trained presiding officers, specifically trained on the Equality Act. At some point, the Department of Justice did quite a bit of work on publicizing the equality courts. I think much more can be done to get the message out that this is an avenue that ordinary South Africans can explore as well. You don't need a lawyer to go to the Equality Court. You fill in I think a 6-page form to lodge your complaint, and the magistrate is allowed to become, to take an inquisitory role in these courts, not the normal, where the presiding officer is a neutral umpire sitting back. In these courts, if the plaintiff is not represented, the magistrate may take quite an active role in the process. But I'm speaking to attorneys today, lawyers today, so this is another avenue to explore to lodge complaints. So no summons, no particulars of claim, a 6-page form where you lodge your client's case in the Equality Court. The third and fourth bullets on that slide illustrate the kind of remedies that you can think about if your client comes and speaks about what they've experienced. What kind of remedies are available in the Equality Court? All the normal, ordinary remedies that you would expect are there, but many others as well in Section 21 of the Act. That, for example, allows the third and fourth bullets to also come into the picture. A more equal South African society. And then the last bullet, probably the most difficult, is it possible to change people's mindsets and values using the law? The law on its own obviously can't do that. All the other social science disciplines have their role to play as well, but the equality courts do have that option as well to try and think around remedies that could also change people's hearts and minds and mindsets. I spoke about the remedies in the Act. Just back to that for a moment again. So if you have the Act available, Act 4 of 2000, Section 21, if you go to that section in the Act, you will see a long list of possible remedies, and it's not a closed list. Any appropriate relief may be granted by the Equality Court. So it's an invitation to plaintiffs, lawyers, to think really hard about what would be the best remedy for your client, what would be the most effective remedy, taking it back to the purpose of the Equality Act. A different kind of South African society, a more equal and a more caring South African society. How do we get there using remedies in courts? And then just a reminder as well that standing in this act is also much broadened. It takes its cue from the Constitution as to what's who may act as plaintiff in the proceedings. You see the Human Rights Commission in their own name, and they've taken quite a few claims in their own name to the Equality Court. NGOs may act on behalf of clients. Class actions are allowed, so a broad range of options available. It doesn't have to be the plaintiff in their own name. It can be any other interested party that can bring the claim on behalf of the plaintiff. The Equality Act allows for 4 causes of action. I'll mainly deal with unfair discrimination today. There's not enough time to deal with all of this in detail. So unfair discrimination, publication of material that unfairly discriminates, hate speech, and harassment. All of these claims, and I'll get to that on the next slide, all of these claims have to be based on a prohibited ground. So this is not a general, these are not general causes of action. They all have to be linked. So there's a definition for each of these causes of action, and they all have to be linked to a prohibited ground. So the state may not, starting with unfair discrimination, then the state may not unfairly discriminate, and no person may unfairly discriminate. And for the attorneys listening, then having in mind what your clients may be bringing to you for a claim to succeed, or the work that the plaintiff has to do is to show that there was discrimination. It's on the respondent to justify the discrimination, to argue or to persuade the court that the discrimination was fair. The work that the plaintiff must do is to just indicate that discrimination was present, which then means any act or omission which directly or indirectly either imposes a burden or withholds a benefit from any person. And there is the catchphrase in all of the causes of action in this act. It has to be based on one or more of the prohibited grounds. I take it you're all familiar with the difference between direct and indirect discrimination. And then in the last bullet, the indication there, one or more of the prohibited grounds, you don't have to base your claim on a single ground. And often a single prohibited ground does not capture the full disadvantage that your client may have suffered. It's often a combination of grounds that worsen the disadvantage, or where it becomes clear that there's a link between HIV, TB and another prohibited ground, and that you have to bring your claim as a combination of grounds to really capture the full picture of what your client faced. So you don't have to only pick one ground. It's not cherry picking or pigeonholing. You bring the full picture to court, the full contextual disadvantage. And that's often then done with, HIV, TB in conjunction with, for example, poverty or race, or whatever other ground may be relevant. Spending a bit of time on prohibited grounds, then you will see there's a A and a B list in the definition of prohibited grounds in the Equality Act. So from the A list, the listed grounds, you will see that HIV is not mentioned, or HIV status is not listed by name. TB is not mentioned by name. Health is not even mentioned by name, or health status is not even mentioned by name. The only prohibited ground that could perhaps be creatively interpreted to perhaps capture HIV or TB is disability, but that's not a great fit. So the A list does not give attorneys a lot to work with if you are specifically wanting to base your claim on discrimination based on HIV or TB. The A list does not offer a clear answer that you will be able to base your claim on a listed ground. So HIV and TB not listed by name, or health status or health condition not listed explicitly. So you will probably have to fall back on the B part of the definition, any other ground where discrimination based on that other ground either causes or perpetuates systemic disadvantage or undermines human dignity. So you may have to have a combination of facts and expert evidence, some empirical work perhaps that you would need to do depending on whether courts have recognized HIV or TB as a probative ground yet. HIV, you will see that the Constitutional Court has sorted that out many years ago already. But if TB, if there are no, forget about the Equality Court for the moment. If there are not other case law that you can fall back on to argue that TB has already been recognized as a probative ground, you will have to have some facts and expert evidence, perhaps, to make the claim that discrimination based on TB would either cause or perpetuate systemic disadvantage or undermine the dignity of your client, to make a claim that TB should also be recognized as a probative ground. Just back to, for a moment, to how to make the argument around recognizing HIV and TB as new additional probative grounds, where you can also state or base a claim based on unfair discrimination. The listed grounds are all broadly constitutive of human identity, sometimes immutable biological characteristics, or a part of the associational life of humans, or the intellectual, expressive, and religious dimensions of humanity. That's what most of the listed grounds capture. And then moving towards, or the fifth bullet, another way of thinking around these additional grounds is grounds that are used to categorize or marginalize or oppress people who have these characteristics, and their HIV and TB, I think, would fit that bullet. A question that's not directly answered in the definition is, what about perceived status? You will see I mentioned one example from an Equality Court case where the claim was based on hate speech, and the phrase was something like, "I see you've lost a lot of weight." So that could play into a perceived status of a perceived HIV positive status, for example. Should that be recognized as well? For harassment, perceived status is explicitly listed in the definition, but for the other causes of action, that is perhaps a legal argument that you would have to make. If your client was perceived to be HIV positive or perceived to have TB, and that disadvantage followed from that perceived status, that has not been clarified in our law yet. So again, just making a claim for the recognition of HIV and TB as new additional probative grounds is to think around the purpose of the Equality Act and equality law in general, that we want to create a country based on inclusion, redistribution, transformation, participation. And again, I think on those four bullets, pretty clear that HIV and TB fits that argument as well, that these grounds should be recognized. HIV and TB should be recognized as additional probative grounds of discrimination. So in the Hoffman versus SAA case, HIV was recognized as a probative ground and explicitly mentioned in the Constitutional Court judgment that HIV positive or people living with HIV, one of the most vulnerable groups in society. That was the main argument used to recognize HIV as a new additional probative ground. There was a Labour Court decision, and I'm starting to work towards what to do about TB then. Do we mention TB by name, or do we use a more generic health status or physical health or medical history ground as a new recognized ground to then also capture TB under the generic heading health status? And that's why I mentioned the Marsland case, where an aspect of health was recognized in the category of mental health, where the complainant had a nervous breakdown leading to depression, and based on his depression, he was victimized in his workplace. So mental health recognized, again, mental health not listed explicitly in the list of probative grounds, but the door was, or the new ground was recognized. Mental health was recognized in that decision. So the door has been opened for an argument around, and again, this will be for the lawyers to work out what exactly they want to call this new ground. But one possible name for it would be health status, or perhaps physical health or medical history, but to find some way of naming the new prohibited ground to capture TB as well. So HIV has been recognized as a ground. It's to think around what to do about TB, how to make the legal argument, which facts that you would need, what kind of evidence you would need to present, plus what kind of legal arguments you would have to present for a court to recognize TB as an additional prohibited ground of discrimination. So there was an American author that gave a very broad definition of what health status as a prohibited ground could entail. Any diagnosed health condition or illness or disease, or any genetic and other disposition to illness or injury. It could be that the respondents will say that's much too broad, and then offer up all kinds of arguments around for, and you will see there in the brackets, make all kinds of arguments about how we treat smokers or obese people, and that should all of this then should be then capture all kinds of discrimination. Should all of this be called discrimination? Because once you recognize a new ground of discrimination, then the door is open to all kinds of claims. And this is a respondent's argument, to say that if the definition of health status is too broad, that you capture too many claims that should not have properly been before a court. If you want to specifically think around an argument, a legal argument, how to recognize HIV or TB as new additional grounds, and there I mentioned some stereotypical ideas around stigmas and reasons used to stigmatize and shun HIV positive people and people living with TB. It's painful to read. I apologize that I have to put that on the screen, but that's the kind of thing that's come out of some empirical research on the experiences of people living with HIV and TB, the kind of stigmas that exist and are sometimes mentioned when they have group interviews around what people associate HIV and TB with. So clear stigma in those last two bullets on that screen. Clear stigma, clear marginalization, clear shunning going on. So based on that kind of argument, you could say that HIV and TB should be recognized as prohibited grounds based on the pain, the stigma, the shunning that goes on in South African society related to HIV and TB. And that could be the line to take in the Equality Court then to make an argument that TB should be recognized as a new additional ground. On the next screen then, and this is on the assumption now that the court is satisfied that TB should also be recognized as a new additional ground. The work is not done. The plaintiff has to show, just to think back to the older slide, that the plaintiff has to show that there was an act or omission from the respondent causing disadvantage to the plaintiff based on a prohibited ground. You would then make the argument that HIV has already been recognized as an additional ground, or you make the ground that TB should be recognized as a new additional ground. That's the work for the plaintiff. The defendant then has to persuade the court that if there was discrimination, that the discrimination was fair. And the plaintiff can't just sit back and be quiet around this. They will have to listen to what the defendant offers the court and then have some kind of response to that to make an argument that the discrimination was indeed unfair. So Section 14 in the Equality Act presents a long list of factors that a court may use to decide if the discrimination against the HIV positive or person living with TB plaintiff, whether that discrimination was fair or unfair. It's an open list again. It's an open-ended list of factors. And it's a value judgment that a court makes, and any value judgment, there's some uncertainty in that. These factors only provide some guidance to a court. Much will depend on the arguments that the lawyers make before the Equality Court, how you frame your arguments around fairness and unfairness. The main work is done in section 14.3 of the Equality Act around fairness or unfairness. 14.3a, whether discrimination impairs or is likely to impair human dignity. I hope it's clear enough that if the discrimination impairs or is likely to impair human dignity, that's an indication that the discrimination was unfair. B, the impact of the discrimination. The more severe the impact, the more likely unfair discrimination. The position of the complainant in society and whether she suffers from patterns of disadvantage or belongs to a vulnerable group. If the plaintiff can be fit into a vulnerable group of South African society, that's also an indication that the discrimination is more likely to be unfair. D, the nature and extent of the discrimination. That's an open-ended factor that will depend on the context and the facts that the lawyers present to the Equality Court. E, whether the discrimination is systemic in nature. Systemic discrimination more likely to be found to be unfair discrimination. 14.3f, whether the discrimination has legitimate purpose. So that could be something that a respondent would want to use to say that, fair enough, I've discriminated against the complainant based on their HIV status or their TB status, but I have very good reasons for having done so. And then G, that links to F. It's one thing to say that you had a legitimate purpose, but what you put in place or whatever whatever the act or omission is that you're being faced with, did you actually achieve that legitimate purpose? Because it's one thing to say what you have in mind, why you discriminated, that you may have had a good reason, but is that what you actually achieved with the way that you discriminate? H, whether they are less restrictive and less disadvantageous means to achieve the purpose. That links to G as well. So even if you can persuade the court that you had a proper reason for doing what you did, for the respondent, in other words, that you had good and proper reasons for discriminating against the person living with TB or HIV, but that you did not think carefully enough about how you go about your business, and that you were too drastic in how you approach the problem, that there was a less restrictive means of doing it. That would be an indication that what you are doing is unfair, that you should have opted for the less restrictive means of achieving your legitimate purpose. And then I, was there something that the respondent could have done, some reasonable steps that the respondent could have done to address the disadvantage or to accommodate diversity? So I is more the first one, address the disadvantage which arises from or is related to one or more of the protected grounds. So if the respondent realizes whatever I've put in place is going to discriminate against people living with TB or HIV, but at least I've taken some steps to address the disadvantage that I'm causing, that would be an indication that a court may reward that respondent then with a finding of fair discrimination if you have tried to lessen the impact of your discrimination.
Prof, you've got 5 minutes left.
Thank you. So the few Equality Court cases that I could find on where HIV status specifically was the recognized ground, there are quite a few complainants that brought claims based on the disclosure of their status. This is at match court level. And this was based on court files at magistrates court, which are sometimes not very clear from what's in the court file as to on what basis these claims were dismissed. So sometimes the claims were accepted, sometimes dismissed, sometimes dismissed because the complainant didn't come back to court. So it's a bit difficult to work out sometimes why exactly was the claims dismissed, but many of these were dismissed, and it could have been, for example, all employment matters go to the CCMA and Labour Court. So it could be that these were dismissed based on that reason, a jurisdiction reason, or it could be that the magistrates argued, but the mere disclosure on its own, and again, this will depend on what's on that form that you complete, the 6-page form that you need to complete. If there is no indication in that initial form that you lodge that there was some disadvantage that was caused to the complainant based on the disclosure, I'm guessing now. I'm trying to work out why these claims were dismissed, because at first sight, these claims seem to be proper. But if your status is disclosed, that should at least be an argument to make in court, that you should have that option. But some of these claims were dismissed based purely on the 6-page form that the plaintiff completed and the respondent's initial response. So on the papers already dismissed sometimes, and not always clear from the court files why that was done. The claims that generally succeeded is where the disclosure was done in a derogatory way. And I give some examples there. And you would see not big amounts, but at least some kind of acknowledgement from the court that the Equality Act was breached, was violated. I could not find any cases related to TB specifically in the Equality Court, but at least some. So the upside of this is that HIV is clearly a recognized ground for a claim based on discrimination. We'll have to see if lawyers start using the Equality Courts for TB-related cases as well. But for the moment, the Equality Court cases on HIV status, and again, of course, courts are reactive institutions. They wait for the claims to come to them. They don't initiate. They can only deal with what's in front of them. And most HIV-related cases that's come to the Equality Court was disclosure cases or hate speech cases. I did not find any discrimination cases as such. As I said, disclosure or hate speech claims. Hate speech in the Equality Act then defined as no person may publish words based on one or more of the printed grounds that could reasonably be construed to demonstrate a clear intention to A must now be disregarded. That's been, the Constitutional Court has found that A is too broad. So we're left with that these words must be able to be reasonably construed to demonstrate a clear intention to be harmful or to incite harm or to promote or propagate hatred. And look, the argument could, of course, be that many of the stereotypes used against people living with HIV and TB, that many of those stereotypes are in any case harmful. So perhaps we did not lose too much. I was disappointed that the word hurtful is no longer in the Hate Speech Act, but that's right in the Inequality Act, but so be it. I think there's still a strong argument to make that most stereotypes are in any case harmful, and that not too many claims have become impossible now. I think harmful still captures most of what we would like to cover in a hate speech law, in a country based with or where deep prejudice still exists, that you would want an act in place that addresses that kind of very harmful messages, and that there's a lot of work that can be done in the hate speech prohibition as well around harmful prejudices, harmful stereotypes surrounding HIV and TB. One more. Let me quickly refer to the definition of harassment. All I want to point out here is, and I highlighted it in the B part of the definition, where it says a person's membership or presumed membership of a group. So for harassment, there is a clear claim recognized on perceived status. Unfortunately, that wording was not carried through to hate speech and to discrimination, but perhaps there's a clever lawyer's argument to be made that perceived status should also be captured in, or should be read into, discrimination and hate speech as well. I'll leave it there. But though obviously during the Q&A and then any follow-up emails, quite happy to take anything else from you in the coming days and weeks. Thank you.
Okay, thank you, Prof. Anton, for that comprehensive overview. I'll now be handing over to Jackson Mzila. As I mentioned earlier, he is an attorney at the South African Human Rights Commission. And as Prof. Anton mentioned, the South African Human Rights Commission has taken on a lot of cases to the Equality Court. So Jackson, can I hand over to you?
Thank you, Chantal. Let me just share my screen quickly. Can you all see it?
Yes, we can see it.
Okay, mine is going to be a very short presentation because most of the issues that I would have otherwise covered in my presentation have been covered by Professor Anton. So just give me a second to just get my bearings. Okay. I think the introductions have already been made twice by Chantal, so I won't repeat. Let me just jump right into it. So I'd already advised Chantal that in the recent past, as the Human Rights Commission, we had not received any complaints relating to HIV, unfair discrimination based on HIV status or AIDS status. But a few years back, maybe 10, 12 years ago, we did receive a few complaints, and they were dealt with in terms of our complaints handling procedures. So maybe let me just explain how the Commission handles complaints so that at least we are on the same page. Am I audible? Maybe I'm just speaking to myself before I continue.
Yes, no, we can all hear you.
I'm looking for my video to show my video. Just I can't find the videos, the video icon.
If you go to view in the right-hand side, oh, there you go.
Oh, yes. All right. Thanks a lot. Let me just go back now to my original screen, the way I was sharing. Yeah. Okay. There we go. So when the Commission receives complaints, so we handle the complaints in one of three ways. We either we make an assessment and make a determination, and we decide whether to investigate a complaint. So by investigate, we mean that we look into the allegations, we put the allegations to the respondent, we get a response, and then from that response, then we can draft a report with adverse findings against the respondent if they are indeed human rights violations, or we can refer the matter to the Equality Court or any other court for that matter. We litigate. And then the third manner in which we handle complaints is whereby we utilize alternative dispute resolution, whereby we mediate, conciliate, or negotiate the complaint. So those are the three mechanisms utilized when we receive a complaint. So I think 10 years back, we received complaints relating to unfair discrimination based on HIV status. How those complaints were dealt with, I think it was a mediation whereby the parties were brought together and then the matter was settled between the parties. So the matter was never referred to the Equality Court, and neither was there a report emanating from that investigation, because we decided to utilize the third mechanism of our complaints handling processes. So those are the three mechanisms that the Commission utilizes. And then just to jump on the next slide. So the Prof has already touched on unfair discrimination, Section 9 of the Constitution and the Equality Act. So I won't really dwell much on that or go into that in detail, except to say that from our own assessment with regards to HIV, unfair discrimination based on HIV status and AIDS, the most cases that are reported that also come our way, but we end up referring them to the Labour Court, unfair discrimination arising out of, arising in the workplace. So you find that someone was unfairly discriminated at work based on their HIV status, and then so that matter, usually what we do is that we refer that matter to the other CCMA and to the labor court. That's what usually happens. So we don't really get to deal with most of those complaints, you know, or we don't get to really refer most of those complaints to the Equality Court. And I think the professors already mentioned the case of Hoffman versus South African Airways. That's one of the examples of, you know, of cases where the court dealt with unfair discrimination based on HIV status. So that's the challenge that we face as the Human Rights Commission, that when a complaint comes to us, usually it's a complaint that's already been either reported to the CCMA already, it's already proceeding in the labor court, and the person just wants an alternative forum to refer a complaint to. So by the time it comes to us, we can't now, you know, subject the respondent, you know, to be, you know, to two forums. So therefore, we advise the person to rather, you know, allow the labor court processes to unfold and be finalized instead of us, you know, subjecting the respondent to forums, which is unfair on the respondent. And then with regards to the Equality Court, Professor already touched on that. So in terms of Section 21F of the Equality Act, you know that the Commission is one of the organizations that can bring matters in the Equality Court. We can bring the matters on behalf of an individual, on behalf of a group of people, or on our own accord. So if you get a complaint, we can, or if we see, maybe we see a complaint in the newspapers or in the media, we can just make a determination as a commission to refer that particular complaint to the Equality Court. So if you look in the past 4 years, the kind of complaints that we've been receiving are race-related complaints. Sometimes we receive complaints relating to unfair discrimination on the ground, on the basis of sex, you know, issues touching on the LGBTQI plus community. So those are the kind of complaints we receive and the kind of complaints we've dealt with in the recent past. So with regards to unfair discrimination, based on HIV status, those complaints we haven't really dealt with. We haven't really referred any of those to the Equality Court in the recent past. So maybe the reason why that is so, I think, let me touch on that on the next slide, is that there are challenges with the Equality Court that we have noted as a commission, you know, based on our experience in that particular court. Maybe one of the issues, if you look at the regulations of the Equality Act, it states, and even the Equality Act itself, it states that the Equality Courts are meant to be informal. So basically that anyone's supposed to access these Equality Courts. A layman is supposed to walk from the street and get into the court and be able to utilize the court and be able to get assistance, you know, in that particular forum. But what usually happens is that now the magistrates, they've now formalized the Equality Courts without any instruction from from the Minister of Justice or from the judiciary. They've now formalized the Equality Courts in that when a litigant refers the matter to the Equality Courts, they are now required to draft, you know, a founding affidavit on top of filling out the Form 2. So now they want you to attach the founding papers or a founding affidavit on that Form 2, which is already an affidavit on its own. So once I fill in that form, I'm not supposed to be now drafting another founding affidavit. And then in the recent matters that we dealt with in Pretoria, for instance, where one party was represented, and so we tried to raise this issue with the presiding officer there to say, you know, since one party is presented, rather let's make this a more of an informal process, where as attorneys we pull back and allow the parties to try and resolve the issues or to address the court. But you find that, you know, because one party is represented, the presiding officer says no, the other party must go and get an attorney to represent them. So now that also contributes to the formalization of the process, because the court should have actually opted to allow the parties to present their cases on their own, and just and the attorneys just to play more of a monitoring role of what's happening in the proceedings. But the courts now, they are pushing for that whole formalization that both parties must be represented. And then at the end of the day, what happens is that the whole proceedings becomes so formal that the complainant and the respondent, they don't even understand what is going on now. They are also lost. They don't understand the legal jargon. They don't understand what is expected of them. They don't understand the legal process, even if you explain to the parties. But the moment you're explaining that, as a lawyer, you can't run away from the legal jargon and the legalese that you're used to, you're accustomed to. So, it just ruins that whole informal nature of the proceedings. So that's the major challenge that we are facing in the equality court at the moment. And then the second challenge is that if you look at the court clerks, they are not properly trained to deal with equality court. So, for instance, maybe one can say you refer a matter to the clerk of the equality court today, and then you find that his interpretation of the act or the regulations is different from another clerk in a different magisterial district. So I think the issue here is that maybe they are properly trained, but there is no refresher training because the equality courts are not so much utilized. So maybe you find that there are courts, especially in the east of Joburg, where you get a court that is a clerk for 3 years, but they've only dealt with 2 or 3 matters in like 3 years. So you can imagine now, if I've been trained only to deal with equality court matters as a clerk, if I only get 1 matter in a year, I'm sure then I'll definitely, it's obvious that I'll forget everything that I've learned or that I've been trained to do. So I think there's no refresher training that is being provided by the Department of Justice with regards to that. That's a major challenge. And then you find that with presiding officers now, what happens now with unfair discrimination matters, especially with issues relating to HIV status, unfair discrimination, you find that now, because it also falls under harassment, that matter is referred to the harassment court. So it's no longer dealt with in the moment you refer the matter to the harassment court, it's no longer being dealt with in the equality court, which is where it's supposed to be dealt with. Because if you look at the Equality Act, it makes provisions in Section 11 for harassment, and Section 10 for hate speech, for both of them to be dealt with in the same forum. So what happens is that courts are separating this. They're separating harassment and unfair discrimination and taking harassment to the harassment court. So once you remove that particular matter from the equality court, you are now disadvantaging the litigant, because now you're no longer, the relief that is being sought in the harassment case is sometimes different, though it's supposed to be the same in terms of Section 21 of the Equality Act. It's supposed to be the same, but now the magistrate in the harassment court has not been trained to deal with unfair discrimination. Therefore, the way he's going to apply the law, the way he's going to handle the matter is by granting a protection order, for instance. So he grants a protection order instead of actually looking at sensitization, an apology, a deterrent in the form of compensation. So those are the challenges that we've been facing. So maybe the issue now is that, as pro bono, since you're in this space, you've got all these webinars, you are interested in unfair discrimination. Maybe the webinars going forward should be utilized as some form of an awareness tool to ensure that everyone is aware that the equality courts and what is the function of these equality courts, because those are the challenges that we've been getting. I think for now, let me just end here, and I'll wait maybe further questions, if maybe one wants me to elaborate or expound on everything that I've spoken. Thank you so much.
Okay, thank you, Jackson. Are there any questions from the participants? I see Alice has got a question.
Yes, thanks to both speakers. And I'd like to put this question to both speakers, just to get their perspectives on this issue of the formalization of the equality courts. The original intent was for these to be user-friendly and layperson-friendly, and it sounds like they've turned into more formal court proceedings, which wasn't the original intent. So I wonder if there could be some kind of challenge to that process, be it a lawsuit or perhaps be it an attempt to have a discussion with the courts and the Judicial Service Commission or whoever it would be who would oversee these kinds of issues to bring to their attention that this forum, which was supposed to be user-friendly and layperson-friendly, has turned into something else. So just to get their perspective on that possibility. Thank you.
I can respond to that if you don't mind, Professor.
Yes, sure, Jackson, you can go ahead.
All right. Thank you for that question. What we did recently, I think it was as recent as 2018, the Deputy Minister of Justice, I forget his name.
John Jeffrey.
John Jeffrey, yes, I'm not supposed to forget his name. So we had a colloquium whereby we discussed the challenges that we're facing in the Equality Court. So we raised these issues. All these challenges that I'm raising now were raised with the Department of Justice. And they say that they will attend to refresher trainings. So I see that in most courts, they've done that, refresher training of the court clerks. But this issue of the informalization, the formalization rather of the Equality Court is still outstanding. That's the issue now that still needs to be dealt with. And every time we appear in court, we try and speak to presiding officers to try to formalize the whole process. But there's a reluctance by the presiding officers. So what we can still do from our side is that we've got an equality court, an equality division within our research unit. So they always solicit our basically our submissions with regards to challenges that we're facing in the Equality Court. Maybe we can submit those to them again. They can resubmit them to the Department of Justice. But I know they've taken some form of steps to retrain, but they've only done the retraining, refresher courses for clerks. And according to the Magistrate Commission, the presiding officer is supposed to be next on that list for the refresher training. But we don't know when that will be done or that will be conducted. Thank you.
Prof. Anton, can I? Okay.
Yeah, if I can offer, if the proceedings are being formalized, that sounds like the courts themselves are now in breach of the Equality Act. To me, that sounds like unfair discrimination based on poverty at least. If you're an unrepresented litigant, you don't have an attorney, it means you don't have the funds to have an attorney. And if the process then becomes formalized, that is disadvantage based on socioeconomic status or poverty. So the courts themselves are now, if that's the case for most of the equality courts, that sounds like a breach of the Equality Act and even the Constitution. So yeah, there will be ways. I think that there should be, if that's the case, if magistrates are now acting outside of what the Equality Act and the regulations prescribe, that's not at all what these courts were about. So yeah, it sounds to me like the courts themselves, that they so probably at high court level then and SCA and CC level to get clarity on what these courts are supposed to do. It was supposed to be informal, accessible, to allow unrepresented litigants to go to court and to be properly dealt with, to allow effective remedies where the facts and the law scream for it. So yeah, I was not aware of the formalization process, and that to me is a step back to what this act was supposed to do. We're not going to realize the promise of the Equality Act or the Constitution if we don't allow for that. Of course, it's in a litigant's best interest to have an attorney. But the regulations allow, if you don't have an attorney, you don't have the funds to have an attorney, or an NGO is not on board, or a class action is not the appropriate way to deal with it. So an unrepresented litigant with a smallish claim, like you would have in the small claim court, that kind of process. So a smallish claim based on one of the causes of action in the Equality Act, that the magistrate is then supposed to step up and ensure that justice be done. So there are legal arguments to say that you should, step back and go back to what the regulations for the Equality Act prescribe: informal, accessible. and for the magistrate to play an inquisitorial role if there's an unrepresented litigant, not to formalize the process.
So it sounds to me like some clever public interest lawyers need to take up this case. Yeah, right?
Are there any follow-up questions on that one? Jackson, I just have a question for you. You mentioned that the Human Rights Commission uses mediation, and Prof. Anton touched on the issue that TB hasn't been listed as a ground. So I just wanted your sort of view that if a complainant came to the Human Rights Commission with a TB complaint, a discrimination based on TB, would precedents and creating precedents influence the Human Rights Commission's decision on whether they would mediate or actually litigate it further so that TB could be a listed ground in terms of the Act?
I think that'll be informed, by our assessment that we conduct then, and also with mediation, alternative dispute resolution, it's a voluntary exercise. So you have to inquire from the parties if are they both willing to mediate, and if they are willing to mediate, then you mediate. But if they're not willing to mediate, then you utilize one of the other mechanisms, litigate or to investigate. But I think as an institution, we're always looking to create precedent. So I think we always welcome new challenges, new issues that have not been conversed in the in the legal fraternity. So I think we'll be definitely, the commission will be open to addressing such issues if they do arise or if they are referred to us.
Okay. And then in respect of the Human Rights Commission receiving complaints from lawyers on behalf of litigants, do you get a lot of that? Do you find that lawyers and law firms are aware of the mechanisms that the Commission offers?
We do get referrals from attorneys, but you find that they are not aware of how the equality court works. And they're also not aware of our mechanisms, especially with regards to alternative dispute resolution, that whenever you present it to them, they now want to inquire further as to how it works, what is the outcome, is it voluntary, So most people are not aware of what, the mechanisms that we utilize. They just know that the commission investigates human rights. How we do that, I don't think everyone is well versed on that. So I think they need to be that awareness exercise. Maybe we need to send out newsletters to law firms so that everyone knows exactly what our mandate is and how exactly we execute that mandate.
Okay. Yeah, I think that's something we can probably explore further, because lawyers just, they sort of, the first thing on their mind is let's put in a damages claim. And I mean, like Prof. Anton mentioned, there's a host of remedies under the Equality Act, which looks at the broader issues of society. So I just want to check if there's any further questions. Otherwise, Alice, I'll hand over to you so that you can close off for this morning. Alice?
Hi. No, I was waiting to see if we had any more questions. No, but thank you to Professor Anton and to Jackson. Thanks very much for this very informative session. I hope that we will be able to get more attorneys, public interest lawyers and private firm attorneys to look at the Equality Act, particularly with regard to HIV and TB. But this has been, quite thought-provoking. And I still want to turn over in my own head, the ways in which perhaps there ought to be a challenge to this formalization process. So thank you for giving us these words of wisdom and these thoughts and these overviews. And I also want to say thank you to Chantel and to Marco, who have put together these webinars and have done a wonderful job in bringing these issues to the attention of our network. So with that, thanks to everyone, and please stay safe and get vaccinated, get your jabs. Thanks.
Thank you.
Thank you.
Thanks. And
Thank
just
you.
a reminder to everyone that these webinars are available on YouTube, and we've also updated the resources on probono.org's website, which includes the legislation we've discussed, that includes the case law. So please have a look if you're stuck in representing your client, and we'll be sending out a flyer for our next webinar. So look out for your inbox. Thank you very much. Okay, bye-bye.
Thank you.
Cheers, Chantal. Cheers. Bye.